Thank you so much, Sarah. A very good afternoon, ladies and gentlemen. And it is still the morning here in Colombo, so a very good morning to all of you who are joining from this part of the world. As the chairperson, I warmly welcome all of you to the third session in the 8th Frontiers in Environmental Law Colloquium, jointly organized by the Centre for Environmental Law, Macquarie University, Australia, the New Zealand Centre for Environmental Law, the University of Auckland, and the Global Network for Human Rights and the Environment. I would like to start the session quoting a poem by Sarah Teasdale titled, "There Will Come Soft Rains." Let me quote, "There will come soft rains and the smell of the ground, and swallows circling with their shimmering sound, and frogs in the pools singing at night, and wild plum trees in tremulous white. Robins will wear their feathery fire, whistling their whims on a low fence wire. And not one will know of the woe, not one will care at last when it is done. Not one would mind, neither bird nor tree, if mankind perished utterly. And spring herself, when she woke at dawn, would scarcely know that we were gone." Unquote. The poem shows that the mankind is not as important as we often assume us to be. If we are gone tomorrow, completely vanished from this earth, the nature, the birds, the mountains, the seas, the trees, the flowers, they will hardly notice that we are no longer here. I selected this poem because I thought it goes perfectly in line with the theme of the present session, Interrogating Anthropocentrism in Environmental Law. We have engaged in anthropocentric or human-centered environmental decision-making for decades, if not centuries. But we have not found conclusive answers to any of the pressing environmental issues. We did not completely eradicate, eliminated environmental destruction, environmental pollution, habitat loss, extinction of species, or any of the environmental issues. If anything, environmental issues have become even more complex, even more complicated, omnipresent, and multifaceted day by day. So I think there cannot be a better time to interrogate anthropocentrism than today, right now. At this session, we have 8 wonderful presenters with 4 very interesting presentations, and I'm certain that this session is going to be full of novel, inspiring, and intriguing ideas. Dear presenters, you have 15 minutes for your presentation, and I very kindly and respectfully request you to strictly adhere to the time allocated to you so that we will have enough time at the end of the session for discussion, questions, and answers. I will ring the bell once at 13 minutes, twice at 15 minutes, so that you will know when you have to conclude your presentations. And I will also share these times with you through the Zoom chat. Dear audience, we will be holding the questions and answer session at the end of all the presentations, and I'm extremely grateful if you can kindly mention to whom your question is directed at when you are raising questions. To formally commence, let me introduce the presentation, the first presentation of the session titled Te Ora a Ururoa, Learning from the Mahi of Kaitiaki. The presentation is the result of a joint research carried out by Dr. Muru Lanning, Dr. Kerry Mills, Nagoya Harrison, Gerard Lanning, and Charmaine Tukire. The research will be presented by Kerry, Harrison, and Gerard. Let me tell you a little bit about our presenters. Nagoya Harrison is an artist and a researcher, currently a doctoral candidate at Elam School of Fine Arts and the James Henry Maori Research Center, University of Auckland. She works with different lens-based media, making images that explores tribal histories and protocols intertwined with bodies of water. Harrison's doctoral research examines the effects of the Marine and Coastal Area Takutai Moana Act in 2011 upon Ngāti. Especially, Harrison is interested in many ways that Iwi Maori relate to and look after their environments, which go far beyond the narrow definitions laid out in Crown legislations. Gerard Lanning has practiced environmental and local government law for 24 years, including 11 years as a partner in Simpson Grierson's local government and environment team. His practice has involved a very broad range of environmental law matters, primarily for local government entities, and he regularly appears before a range of judicial and quasi-judicial bodies. He leads the firm's Maori business and climate change groups. At the start of this year, he switched to being a consultant to the firm so that he can work on a PhD, considering the question, what does the duty to provide for the well-being of future generations actually mean? The PhD work looks closely at the interaction between Chikanga Maori and state law and between environmental law and property law. I could not access the biographies of other co-researchers in this presentation, so I extremely apologize for not being able to provide them with a proper introduction. I'm so sorry. With that being said, dear Carrie, Harrison, and Gerald, I warmly welcome you for your presentation.
Tēnā tātou katoa. Ka mihi atu ki ngā tangata whenua o ngā rohe rā ki ngā walu marigal o ngā tangata Darug, i ahi te reiria kia Ngāti Whātua i Aotearoa. Ka mihi ki te komiti whakahaere o tēnei hui ipurangi, a tēnei te mihi hoki ki oku huamahi ki oku hoa ki ngā kai kōrero o ngā kōrero e whai ake nei ko Nagoya Harrison rawa ko Gerald Lanning. And no worries about not introducing me, I'm not giving a proper talk today, but for the record, I'm Kerry Mills and I'm one of the researchers on this project that you're about to hear two sub-projects from. So the wider project is a Te Awharangi Royal Society Marsden funded project on Māori relationships with harbours, which is led by Associate Professor Marama Murulene. The research focuses on looking at the theory and practice of kaitiakitanga, which is often loosely translated as guardianship, but in reality, it's a complex kinship-based set of rights and responsibilities that Māori have with the lands and waters of their rohe, or tribal territories. The project is really deeply focused on the local. There are three main case sites, Kawhia and Aotea in the Waikato, the Manukau Harbour in South Auckland, and the Whangārei Harbour in the north. The project works closely with kaitiaki, who are those who hold kaitiakitanga rights and responsibilities in each of these areas. And the project holds wānanga, which are in-depth discussions over multiple days with kaitiaki of all ages. And we especially focus on women's voices, as wahine Māori often play a leading role in environmental protection. The research seeks to understand kaitiaki perspectives on harbours and their relationships to their harbours, and to investigate the constraints put on those relationships by the operation of resource management and policy, law and policy. So kaitiakitanga is referred to in Aotearoa's key resource management legislation, the Resource Management Act 1991, which is currently in the process of being revoked. And from there, it filtered into environmental policy at all levels of government. There are really serious problems, however, with the way that these policies operate at the flax roots. Central and local government tend to use the term kaitiaki as a shorthand for stakeholder, recognising Māori interests but not their authority, accepting their labour but not their expertise, and very seldom relinquishing any power or finances necessary to allow Māori to exercise kaitiakitanga in the way they would properly practice it. And part of our research is a historical investigation into the way that kaitiakitanga has evolved as an ethic and a politic in Te Ao Māori and as a policy within Te Ao Pākehā, and the fundamental mismatches between those worlds. Heoi, ka hoatu te rākau kōrero ki a koe ngā huia. Tēnā koe te katoa.
Ngā mihi ki a koe e hoa, tēnā koe te katoa. Ko Nagoya Harrison tōku ingoa. My presentation is called The Second Memory of the Government. The talk will briefly describe the background for a creative project of the same name. The Second Memory of the Government takes its name from a literal translation of Archives New Zealand, a te rua mahara o te kāwanatanga. The project is a series of new photographic and video works focusing on the confiscation of common Māori land in the Whangārei Harbour. It's part of my Doctorate of Fine Arts, which sits within our Harbours project at the James Henare Māori Research Centre and Elam School of Fine Arts at the University of Auckland. So as Kerry mentioned, a key focus for the Harbour project is the role of wahine as kaitiaki in harbour spaces. Since the introduction of a patriarchal system in Aotearoa through colonisation, wahine voice has been diminished. Yet in many of the examples of flax roots activism, we see women front and centre. Ruiha Kingi, pictured here in the center of this image, is the tupuna wahine. She's also the catalyst and the Potoko Manuel, the center po of this project. She's pictured here with a battalion that she formed, the Ngāpuhi Nursing Sisters of Mercy, formed at the time of the Boer War. The two stipulations to join the New Zealand Army at the time were that you had to be a man and you had to be a Pākehā, or a New Zealand European. So the record I found in the Wellington archives was a letter written by Ruiha to the Native Minister in 1907. Ruiha was protesting the Harbour Board's theft of 3 parcels of land in the Whangarei Harbour, 3 tauranga waka, which are areas you would leave your canoe when you weren't using it. So in her letters, Ruiha refers to these tauranga waka as having always been kept in commons, or she also uses the word papatupu lands. And this was particularly resonant for me because in my doc research, I was looking at the idea of common marine areas as described in the Marine and Coastal Area Takutai Moana Act of 2011. This act replaced the controversial Foreshore and Seabed Act of 2004. So briefly, the 2004 Act ran with the idea that foreshore and seabed were commons and therefore Crown owned. The replacement 2011 Act says marine areas are commons and therefore no one owns. These pieces, as Ruiha states, had not been passed through the native land courts because they were papatupu land or commons for all Māori, iwi and hapu in the area to utilise. So we start to see the complications when we use words like commons. Well, whose commons and whose use rights are you talking about? Ultimately, the tauranga waka were taken by the Harbour Board, 3 pieces, Otariki, Hihiawa and Puhi Island. The work I'll show next focuses on the Puhi Island site. So this site was bought off the Harbour Board by the Whangarei District Council in '67. The image on the left shows the WDC had big plans for the future of Puhi Island, a public recreation area. There was a lot of conflict over this development. The plans were getting bigger and bigger, but the funding didn't grow at the same rate. So eventually the plans were abandoned and Puhi Island became the dump. So I've been photographing the site, documenting the ways the land holds events and in itself as an archive, which is particularly explicit in this site as it's the place the people of Whangarei have brought their rubbish for over 30 years. I use lines from documents that I find in the archives to title the photographic works. For instance, this title, "The Safe Treatment of Leachate is Crucial to the Success of Any Landfill," was taken from a pamphlet distributed by the WDC, ensuring the public that the necessary health precautions were being and had been used to mitigate the leaching of toxins from the dump into the surrounding environs. And because these strange hills or land formations here at Puhi Island are the result of the council pushing piles of rubbish together to then cap and create hills for walking or bicycle pump tracks, it's an odd place. A commons created out of our rubbish, collected on stolen lands. So things aren't as they seem or aren't as they should be perhaps. And I would say definitely not what Ruiha Kingi had in mind when she took it upon herself to advocate for this area at the turn of the century. For now, we can hope that our Harbours Project's focus on Flaxroot's voice of wahine will bring light to the work of these kaitiaki. Nō reira, kua mutu tuku kōrero, ka huri te wā kia koe a Gerald.
Kia ora nā huia. Kia ora koutou, ngā mihi mahana ki a koutou katoa. An important aspect of the Marsden Harbours project is the interaction between kaitiakitanga and state law on the ground, as we've been referring to the term flax roots. But this interaction is particularly acute in relation to property law and environmental law. For example, we are helping Makatu Marae on the foreshore of the Kawhia Harbour with an issue they have about controlling access of vehicles onto a beach just over the boundary from their marae. But for today, I want to investigate this interaction using the example of what happened at Ihumatao on the Manukau harbour. And the slide that's on the screen at the moment is an image of what was called the Kaitiaki village in 2019. This was a land occupation established by a group of local Māori hapu under the banner of Soul, Save Our Unique Landscape. And it was a protest against a proposed use of Ihumatao, this area of land, for a residential development by Fletcher Residential. So in this very short presentation, I want to do three things. The first is just to very briefly set the historical context in terms of the environmental and property law processes which led to Soul only having a political solution. Secondly, I want to very briefly touch on the effect of property law in terms of locking in particularly strong legal relationships at particular points in time. And thirdly, look at what challenges this presents for the place of kaitiakitanga and the manifestation of tikanga-based relationships generally, especially in the context of environmental law decision-making. So just to give you a very brief overview of where we are talking about, the arrow there loosely points to what is known as Ihumatao. It's a very strategically important piece of land on the southern shores of the Manukau harbour. It's an area of long-standing occupation by Māori. The land was home and economic base for Manukau hapu, and it has particularly high values in terms of soils for cultivating food. Very briefly, the historical context. In 1865, the land was subject to what is known as raupatu. This was a confiscation by the Crown, and in this area, 445 hectares of land was confiscated by the Crown. The year later, in 1866, the Crown granted the land to the Wallace family, who carried on farming and quarrying the land. In 1985, the Manukau report by the Waitangi Tribunal recorded the ongoing effects of the raupatu and saying that, and observing the intense grief felt by claimants, which tended to pervade all aspects of the claim. For them, it is though the confiscations and dealings occurred yesterday. The Crown now accepts that the raupatu was wrongful and unjust, but hasn't accepted that it's unlawful. Up to the more contemporary times, in 2012, there was an Environment Court case where the Wallace family and others successfully challenged an Auckland Council proposal to not zone the land for residential development or urban development. Mana whenua, the local Māori, participated in support of the council. The Environment Court, concerned with the owner's rights to utilise the land, held that the better outcome was to allow urbanisation. The court said to lock the land up might indeed provide for Māori and heritage values, but it would not provide for the needs and economic well-being of the owners. By allowing sensitive, constrained development, heritage and landscape characteristics can be protected while at the same time allowing the owners to provide for their economic well-being. Which takes us to, well, actually before we do that, the decision, that decision was followed very quickly by a series of regulatory decisions which allowed Fletcher Residential to progress in residential subdivision and development. Which takes us to the view of the sort of classic owner view of property. It is ubiquitous, its normative influence is enormous, and it often goes unnoticed. Key characteristics are that there is an identifiable owner with absolute powers within a clear property boundary, including the power to make decisions about how to use the land and who to exclude from it. The property boundary can be seen as a frontier between autonomy and vulnerability, the autonomy of the owner and vulnerability of non-owners. And that those ownerships are fixed at certain points in time and don't change, notwithstanding changes in society and the environment around it. So what does this mean for kaitiakitanga and tikanga-based relationships? As I noted, the owner model is the predominant and perhaps only understanding of property in Aotearoa, New Zealand. It is particularly resilient to change with its focus on and protection of the rights of the owner and its strong alignment with economic liberalism and the market economy. It is why Seoul was left only with a political option in this case. As illustrated at Ihumatao, property law does not allow for the morality of the owner's ownership to be questioned, even if it is questionable. The fact that the land entered into the property law system by way of an injustice is just legally irrelevant. Property law therefore entrenches past injustices rather than facilitates their remediation. And Waldron refers to this resilience as laying a kind of curse on a land. And as illustrated at Ihumatao, this curse can be manifest through environmental law decisions. There is limited scope to recognise the rights of non-owners. The tikanga-based relationships of mana whenua in this case, including those reflected in the concept of kaitiakitanga, did not diminish as a result of the land entering the property law system and having legal owners. But property law does not recognise them as legal rights, despite them arguably displaying property-like characteristics. Kerry mentioned the Resource Management Act, recognising tikanga-based relationships, including kaitiakitanga. They are, however, just one of many considerations when making RMA decisions, including the property rights of owners. They do not constitute property rights. They are interests at most that have legal effect, but only through the operation of the statute. The proposed Natural and Built Environments Act, which, as Kerry mentioned, is part of the reform of the RMA, will include several outcomes to be achieved, including that the relationship of iwi and hapu and their tikanga and traditions with their ancestral land, water sites, wahitapu, and other taonga is restored and protected. The reference to restoring relationships is an interesting one, especially in the context of the seemingly unimpeachable or indefeasible rights of the people who own the land. Ihumatao shows the enormous historical impact of property law on the recognition and exercise of non-legal relationships with place and the challenges this creates for restoring tikanga-based relationships. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa. And Asanka, that's the end of our presentation.
Thank you very much, Kerry, Nagoya, and Gerald, for your very enlightening presentation. It is extremely interesting to learn the concept of kaitiakitanga. I think I pronounced it correct. And what it denotes and how this indigenous and traditional knowledge can be used to develop and shape the law in the contemporary world. Thank you very much. Now, let's move on to our second speaker of the session, Paul Govind. Paul is a lecturer at the Macquarie University Law School, where he convenes environmental planning law and climate law. He's the Deputy Director of the Center for Environmental Law at Macquarie University. Paul is also the Regional Director for the Global Network for Human Rights and the Environment, GNHRE. His current research interests focus on the ethic of responsibility and the relationship with property values and how this relationship might limit the adaptability of environmental law in the Anthropocene. Today, he will be speaking on why biodiversity offsetting is inimical to the ethic of responsibility in environmental law. Paul, you may start your presentation.
Thank you, Asanka. I'm just going to share some slides. I don't have many, but they could be beneficial. So I hope everyone can see that. I'll just try and switch that onto slideshow. There we go. Okay, so as Asanka said, my topic today is on biodiversity offsetting and why this is inimical to the ethic of responsibility in environmental law. So how did I come to this point of, oh, sorry, I think I've skipped a slide already. There we go, back there. How did I come to this point about of looking at the ethical responsibility or ethic of responsibility in biodiversity offsetting? Well, I'm not going to go too much into the background of biodiversity offsetting. I assume most people know what it is. And so very briefly, biodiversity offsetting is nominally, at least, or ostensibly, a conservation technique that is operated and applied within land use planning and development decisions. So in the jurisdiction where I am currently, New South Wales, and in the Commonwealth jurisdiction of Australia, offsetting applies where biodiversity values are threatened by a potential land use project. So from a legal point of view, biodiversity offsetting takes place within the broader parameters of land use planning law. Now, even that in of itself is quite significant, because it tells us off the bat immediately how biodiversity offsetting is going to be framed, and the potential influence it has in terms of mitigating biodiversity loss in the context of a legal system which is designed for the very purpose of land use development. So how did I come to this sort of point in my research? Well, recently, particularly in New South Wales, there's been a lot of concern, consternation surrounding the efficacy of biodiversity offsetting as a conservation measure. In fact, in December last year, 2021, the New South Wales Upper House of Parliament concluded an inquiry into the effectiveness of the biodiversity offset strategy of New South Wales. And this was fueled by concerns that, well, offsetting is not really doing much in terms of biodiversity conservation. Now, I believe that many of the reasons why there is so much consternation around this is a gap, an expectation gap of what people expect biodiversity offsetting to do and what is actually happening. Now, in environmental law, it's often the case where we find that a law is not meeting our expectation. We tend to look at things that are fairly typical to legal design and legal operations, such as compliance, monitoring, it could be even harsher sanctions, things like this. But really, in the context of environmental law in particular, if we want to affect change, if we look at a legal system, and in this case, a conservation device within a particular legal system, if we want to elicit change, we need to look at the values upon which that legal system or a device such as offsetting is based. And analysis in terms of values, I think, holds much more potential in terms of understanding the limitations of offsetting rather than looking at the technical sides of it. When we look too much, I think, at the technical sides of law, we tend to get into a bit of a circular sort of argument, because we're typically looking at issues which are depoliticized, or we assume are depoliticized. Or another way to put that, of course, is we're looking at issues where values are kind of marginalized, and we assume that the issues, such as in this case offsetting, is value neutral. This could not be further from the truth, and that's really what I want to look at today. I'm applying an ethical frame to offsetting, which I believe reveals the values that offsetting represents and why there is this gap between expectation and reality when it comes to offsetting as a conservation measure. Now, I'll come back to the issue of responsibility in a moment, but the key thing for me that really linked offsetting and the mounds of scholarship that's really coming out on at least the technical sides of offsetting was this phrase, the production of equivalent natures. So again, just going back to how offsetting works briefly, in the context of a particular proposed development, a land use development, if biodiversity is threatened, there is an option for the developer to ascertain what biodiversity could potentially be lost or damaged, identify what that is, and then find an alternative location that features those same or close to same, like for like, or whatever the phrase is, biodiversity values. They then commit to protecting that site, that alternative site, and the biodiversity values that occur on that site, and that offsets the damage they're doing at the site of the development. So what offsetting, therefore, is engaging in is this production of equivalent natures. So offsetting, for me, is a particular exercise of human power in order to enable the continued development of land. Offsetting is essentially reconstituting nature. It's reconstituting the nature that occurs at one particular site and saying, well, yeah, according to these metrics, according to these measurements, that same nature, that same biodiversity occurs at another site. And if we protect that, then everything is going to be okay. However, this is, as I said, inimical to responsibility. Now, following on from the excellent first talk we've had, which has actually saved me a lot of explanation on this point, responsibility, the ethic of responsibility has emerged recently in Western legal context because of the Anthropocene. What we find with the Anthropocene is that traditional Western conceptions of humanity's relationship with nature have basically been shattered. The division between humanity and nature has collapsed. Now, of course, indigenous culture and law shows us that this division was always an illusion, but it is something that is novel to Western law, and I think it's important to point that out. So responsibility has emerged in this context, and responsibility very much relies upon this sense of embodiment or re-embodiment of humanity with nature, that relationship which defies the traditional Western conception of division and detachment. And it's essential for responsibility and the ethic of responsibility in environmental law to be built on this fundamental understanding. So how does that then translate into law itself? Well, for this, I follow Peter Burden, who will be talking at the end of our conference in a couple of days, who has said that responsibility in the context of environmental law means that human power should be the focal point of environmental regulation. That's the thing that is causing environmental change, environmental harm, and that should be the subject matter of environmental regulation. But that notion of responsibility, again, relies upon this idea of a sense of embodiment or re-embodiment between nature and humanity. Anything that departs from that, anything that falls back into this idea of detachment between humanity and nature will then fall into the same tropes that has sort of driven us to the Anthropocene in the first place. So the next few slides here are just a few cartoons or comics that help illustrate my point. I won't be talking to them directly, but please, I think, have a look at them, and I think they do sort of flesh out what I'm trying to say. So offsetting perpetuates this division between humanity and nature. And it is vitally important that we interrogate this aspect of offsetting. Offsetting is growing in popularity. It has been now for the best, well, probably over a decade. And not just in Australia or New Zealand, indeed New Zealand, but many, many countries at national and international level. It is growing in popularity. So what we have with offsetting is a technique, a conservation technique, which is very much at the forefront of our response to Anthropocene and our response to biodiversity loss and ultimately potential extinction. Now, offsetting, as I said, perpetuates this division between humanity and nature. It leans into these ideas that the Western legal system inherited from Enlightenment thinking, and that's disembodiment of humanity from nature, detachment from humanity, from materiality of land, and dephysicalization. The idea that values, what we value in land can actually be, can transcend land, can be, what's the word, sorry? Yeah, it can transcend land, can be removed from land and then replicated elsewhere. Now, this idea of dephysicalization really resonates most powerfully in the Western legal model through property. Property is an idea that is imposed upon land. It is of course, a legal construction. There's no materiality to property. But what property does is that it imposes a particular value on land that then does not depend upon the health of that land. And so therefore it runs counter to ideas of materiality and embodiment and re-embodiment. And offsetting, despite it being ostensibly a conservation measure, subscribes to the exact same type of ideology. That's what you want to call it, an ideology. So instead, perhaps, of looking at the production of property value, what offsetting tends to do is look at the production or reproduction of nature itself. But again, it's the same sort of idea, removing the values of nature from the physical materiality of the land. So just go to the next slide, and you get a bit of an idea of that. This ancient woodland has moved. It's the idea that the ancient woodland itself, all, the biodiversity it holds, the values it holds, can simply be transplanted somewhere else. So offsetting in recreating nature or in recreating what constitutes nature does this for the purpose of ensuring approval of land use development that will ultimately result in biodiversity loss. Recreating nature is not about artificial trees or anything like that. It is a reconstitution of what nature means. It is a set of nature values. It allows, a set of nature values to be identified and then recognized elsewhere. This necessarily reduces and diminishes nature to a level of where like for like can be found. While scholarship has explained how this has led to reductionism and quantification, both of these qualities are very important in the assessment process. And the use of this power to recreate nature basically satisfies legal regulation. Indeed, it is the legal regulatory process itself. So biodiversity units are abstracted and detached from the context, again, similarly to the notion of de-physical property and the disembodiment of humanity from nature. It changes the meaning of nature, or potentially can change the meaning of nature, and it changes how nature is valued. In the context of offsetting and the broader context of land use assessment and approval, the value of nature under offsetting, therefore, is enlivened and maximized in the context of the development assessment process. And this ability to reconstitute nature in this way is a demonstration of anthropocentric power. And so going back to Peter Burden's point about looking at power and regulating power, having that as the central focus or subject of regulation, what offsetting is really doing, despite, again, I must repeat, ostensibly being a conservation measure, is leaning into this anthropocentric power. And by power here, we don't necessarily mean power in the sense of technological power, destructive power in terms of removal of trees or damming a river or anything like that. We're talking here about power that can be exercised in nature to then recreate the planet in a way that services exclusively the interests of humanity, the interests of anthropos. So it's interesting to sort of fall back a little bit here on the sort of thoughts of some of the scholars in this space. So Neyrat, for instance, says, power can be understood in two different ways: in political terms as a form of governance or kind of management, as well as its rapport with technology. And that's really here what offsetting is doing in this reconstituting of nature, is this idea of exercising power as a form of governance. To quote then from Foucault as well, this excess of biopower appears when it becomes not just technologically, but politically possible for humans to unleash forces that cannot be controlled and that are universally destructive. And in this case, what we're seeing with biodiversity, and coming back to my earlier point about the dismay about biodiversity offsetting as a means of conserving biodiversity, what we're seeing is that the forces that have been unleashed, i.e. biodiversity loss, potential extinction, these can no longer be controlled by humanity. And going back to that quote from Foucault, this formidable power is being put beyond human sovereignty. So just to quickly wrap up, so I know I'm just about out of time. When offsetting is understood in this context, through this prism of ethics and responsibility, we see that offsetting is incongruent with the basis of responsibility that has been introduced in a rather shattering way to Western culture and law through the Anthropocene. Thank you for listening.
Thank you, Paul. Thank you very much for your very fascinating presentation. I think I totally agree with your idea. Why are we prioritizing our proprietary interest as human beings over the interest of the wider community, where we ourselves are a part of this wider community? Thank you very much. So I would like to introduce our third speaker of the session, Dr. Nelson Quinn. Dr. Nelson Quinn had long experience in Commonwealth administration, Commonwealth state relations, global change and environmental research, also farming industry organization, land care and similar organizations. He has undertaken research at Griffith University and with Australian and overseas collaborators on biosecurity issues, land management law and policy, global change responses, role of agriculture in climate change and natural floodplain management. He had also been chair of natural resource management community groups. When a farmer for 20 years, he was an office holder in cattle and olive industry organizations. He is a director of the ALM Group, Land Management Certification, and secretary of the Serrated Tussock Working Group for New South Wales and the Australian Capital Territory. He was also a member of the Commonwealth Environmental Biosecurity Roundtable and is a member of the Combined Royal Society's Planning Group on New Stewardship of Country. Today, he will be speaking on the topic, New Approach to Land and Seascape Stewardship. Over to you, Dr. Quinn.
Thank you. Welcome to everybody from Komomeri country on the Gold Coast in Queensland, Australia, for those of you not in this country. The last point was about Royal Society's activity. That's what I'm doing today, reporting on the outcomes of a webinar series initiated by the Royal Societies of Australia. The series addressed the question of the need to change our approaches to land and seascape steward to protect and restore them. The thing is called New Approach to Land and Seascape Stewardship, but you will hear that really we're talking about something that's thousands of years old, because our proposal is to base our relationship with nature on an ethic of custodianship of country drawn from Australian Aboriginal experience. We have to do this while recognising and building on our history of our country, its Aboriginal foundation, the modern production systems we have, and our laws and institutions. Now, we want to be practical. There have been too many ideas with little practical follow-up. Indeed, greater attention to Aboriginal knowledge and practices is one of those. We have in fact proposed a whole lot of detailed suggestions about what can be done that do address some of the points made in the previous presentations in our context here. Now, this series was presented by the Royal Societies of Australia and Inspiring Victoria with support from the CSIRO in March 2021. It involved collaboration between Aboriginal and Torres Strait Islander experts, land and sea managers, carers and policymakers, industry practitioners, including farmers, and thinkers. This collaboration ensured a broad range of perspectives on landscape and environmental management, bridging Indigenous, agricultural, scientific, economic and social perspectives. The linking proposition through all this was support for practical action and public good. Now, in Australia, we have busily degraded our unique land and seascapes over the last 220 odd years. Brian Walker, a prominent thinker about resilience problems, poses what I think is the right question in his most recent book, Finding Resilience, Change and Uncertainty in Nature and Society. What he said was, how can we transition to a different way of thinking, a norm that matches the reality of the biophysical world and the reality that individual well-being is largely determined by the well-being of society. That is, we are all in it together and we all depend on nature. We are well past the point where we can go on casually taking nature's resources as if they were indestructible gifts. Now, in this webinar series, we had presentations from Aboriginal and Torres Strait Islander people, scholars, land managers, conservation interests, and lots of discussion. Those presentations and discussions covered Aboriginal approaches, landscape restoration work, lessons from farmers, integrated policy approaches, government failure, law reform, philanthropy, and an already very big rural agenda in Australia addressing social, economic and environmental decline. This long list of things is still not being properly pursued. In the end, we concluded that we needed to apply a law of obligation and custodianship of country and change culture and relationships in respect of land and seascapes and among people. We recognised that meeting these needs requires a transition to restoration and protection of the environment and to achieving social, economic and financial well-being in rural communities and in all Australia's landscapes and seascapes. As one colleague observed, fix poverty first. The task is too important to be left to market forces acting for their own benefit. Markets alone cannot prevent the overuse or irrational allocation of environmental public goods that are apparently available to all. Neither can we rely on a patchwork of all the individual initiatives going on. For example, about floodplains, weeds, vulnerability to bushfires, protection of koalas and other wildlife, coastal erosion. There were several elements to our argument. A starting one is we've no point in trying to reverse history. We can only start from where we are now. That history includes our Aboriginal and Torres Strait Islander foundation of culture and relationship to country, a term that combines land, ecosystems and human cultures in a holistic knowledge system of complex interrelationships. We imported production systems from overseas without realising the impact they would have in Australia. These production systems are in turn entwined with domestic and international relationships. We have been changing, but much too slowly. Our laws, governing systems, many social institutions, and our dominant economic relationships are inherited largely from Britain and other European countries. You could add China now, but those relationships are still based on that European World Trade Organization style history. Now, our future depends on how we build on this history. We believe that our new approach had to acknowledge that economic activity in Australia based on current land uses will continue. These include agricultural and pastoral, mining, infrastructure, urban settlements, culture, recreation, and nature conservation. Given the size of Australia and what happens in it, we also have to recognise that rural, remote and agricultural land management practices are by far the most important drivers of landscape health in Australia. That distinguishes us from a lot of other countries. We also know there will be continuing global changes. People talk about climate change, it's not just that. Global changes affect climate, biodiversity, landscapes, the oceans, hydrology, and pollution has an extraordinary effect as well. We also know we can expect more extreme events and unpredictable outcomes. Now, we cannot just vacate the land. We will need continuing intervention in land and sea processes. People totally dominate environmental impact, as Paul has pointed out, and it's therefore up to us to manage things so that the environment can function rather more like it did about 200 years ago. We must learn to manage with the global changes and adapt to them, not deny them or fight against them. The aim of our interventions then should be to maximise both the natural systems and human well-being in the face of rapid environmental change. So what did we argue for? Are arguing for? It's a continuing process. Acceptance of the principle of obligation for custodianship of country. I'll talk more about that. Reform of our laws and institutions. Well, probably everybody at this conference will say that. And immediate action by government, business, educators, land and sea managers and carers, and all of us in our daily lives. In other words, there are things we can do now, regardless of where we think the big picture should end. Now, on the custodianship of country concept, we had the good fortune for advice about the concept from Dr. Mary Graham. For those who don't know about Mary, she's a Kombumerri person. In fact, she lives in the suburb I live in with Waka Waka associations. She's been a lecturer with the University of Queensland, teaching Aboriginal history, politics and comparative philosophy. She has also lectured nationally and indeed internationally on these subjects. She is one of Australia's leading thinkers, philosophers and governance experts. The custodianship of country involves maintaining a respectful, nurturing relationship with land, place and community to guarantee well-being for future generations. Collaborative and cooperative relationships to support custodianship are necessary for success. Mary says that the custodial ethic, quote, emerges from an ancient reciprocal relationship with nature, an ethic of looking after, stewardship, caring for, and the obligation to look after land that nurtures. This custodianship approach has to be the foundation of our stewardship of country, at least that's what we're recommending. This approach involves priority for support for country on ethical and pragmatic grounds. Firstly, it is the right thing to do. And secondly, we in fact rely on it for our daily living. In turn, our identity, the human part, needs to be defined by and embedded in our relationship to land and sea and by our relationship with other people. We believe we need to generate a sense of country in the community so that country is always the first consideration in our collective and individual decisions and acts. We need a desire to thrive as our paramount consideration. We need a goal of increased and continuing abundance of natural resources. Otherwise, we'll go backwards. Many of our existing laws, practices, and institutions will hamper achieving these aspirations. Not a surprising statement for any of you. So we must change them. In terms of law reform, we need that our institution and laws, by institutions, I mean the whole raft of everything we do that influences our daily activities. We all know what laws are. They need to support more direct citizen input into decision-making, effective rewards and incentives for improved caring for land and sea, more ground level based and community-driven action, and experiments with public input into government and business processes that address the key elements of democratic government, which I believe are participation. We should all be able to be in there somewhere. Openness, we should know what's going on, be able to find out. And accountability, those that make decisions should one way or another be held to account. Now, the test for all laws and their administration needs to be how they support caring for country and avoid or prevent environmental harm. We cannot continue with laws that override custodial obligations to care for our land and sea. We need support from the public for a transition to sustainable approaches. You have to have the mob behind you. Government and business must become more accountable for the environmental impacts of their activities. Now, a lot of that you've all heard before. So then we went on to consider what we could actually do rather than just repeat what will be the obvious to many people. We do not need to wait until everyone has accepted and understood the obligation of custodianship or until all our laws and institutions are reformed. We can act now, collectively and individually. Every small change we make adds to all the others. Eventually, you end up with big changes. When we can act collaboratively, we immediately magnify the changes any one of us can make. Here are some examples of what we thought was desirable action. We want government and businesses to support detailed regional and catchment action plans that prioritise caring for country. We need to restore land care as the grassroots caring for country movement envisaged in 1989 with one community-driven system supported by governments. We need to revive cleaner production and energy efficiency programs. We need to improve waste management and recycling systems. For those of you like me that have been around forever, you will know that all of these have been part of past efforts, but they have been faltering since the 1990s. I'll elaborate on why. Educationists in their turn can establish university departments, programs or chairs based directly on caring for country principles that have an effective community outreach. Now that came from some of our academics in our team who believe that I guess that too much of academia is a bit too siloed still and not enough out there in the public. And also this follows things Mary Graham said, develop a social sciences school curriculum on understanding country, teach school kids how to think, and you do that in part by acquainting them with their local country. Land and sea managers and carers can in their turn incorporate local Aboriginal culture in land restoration and management, talked about a bit but not often done. Weave local culture and non-Indigenous science into management and restoration processes, and focus repair and restoration on the unique and very special aspects of nature and culture in Australia. Now, there are already examples of that kind of thing that we can build on, the relationship between Aboriginal culture and land management and so on. The last one about uniqueness relates to the point that there's no way we should try and do everything in a country as diverse as Australia, and it has such amazing natural resources. It's just not possible. So we have to work out the things that are unique and very special and go to work on those. Now, everybody can do these following things. They can constantly publicise good examples that prioritise caring for country. They can foster collaboration and peer networks aimed at supporting caring for country. They can practice continuous learning and improvement, preferably using quality management systems. Lots of successful managers and so on do that already. You can do it in your daily life too. Adopt environmental charters for our households, farms and businesses. It's remarkable the difference things like that make. We can all become better waste management. That's easily demonstrated. We can all practice energy efficiency, which is becoming more important and popular in Australia anyway. Individuals sometimes will feel lonely and helpless, but as Noam Chomsky, famous activist, pointed out decades ago, what you can do in that situation is join supportive organisations and participate in supportive events. The future. The outcome we're after is to enable ecosystems to function effectively for their own sake and for human well-being in the face of rapid environmental change. Our advice is the transition can be driven by acceptance of the principle of obligation for custodianship of country. This will involve weaving of Aboriginal thinking and non-Indigenous thinking and practice in supporting caring for country on ethical and pragmatic grounds. Paying public money for public goods generated by private action. That's been talked about for decades, I know. And there are unresolved but not insurmountable definitional issues there. There are new developments and ideas under consideration that should help with that. Applying the polluter pays principle in Australia, despite the law, done incredibly narrowly. What it should mean is compensating for environmental damage of whatever kind and its consequences, including for public health problems and loss of amenity. There are implications for international trade in that too, so it's very complicated. Then there's precautionary decision-making to protect from risk. A lot of people at that point throw up their hands and say, we've all heard of that, and how do you do it? It does sound hard, but in fact, it can be reduced to practical steps. And people have been working on that since the 1990s. What you do is you base your action on preferred futures. That would in turn be based on, in part, the Aboriginal approach of, again to quote Mary Graham, we are doing it for the next generation. Continuous learning and improvement, I've mentioned that. Environmental gain test for economic activities, that's been given prominence in recent times by English economist Dieter Helm, but it's a whole thing as well. It's also part of some Australian laws, but not ever implemented to my knowledge. I've already mentioned revival or refreshment of catchment, regional and collaborative approaches. They should be fostered by government. They used to do that. They should be community driven. That used to be the case, but it's died away. And they should be informed by experts and local knowledge, which would of course include Aboriginal and Torres Strait Islander knowledge. Australia used to be well known for structural adjustment programs. They've died away too. We need to revive those. Now, above all, law reform should be just about the highest priority for immediate action, if it could be done. The law should entrench all these propositions. It should make the safeguarding of effective functioning and ecological integrity of ecosystems the overriding consideration in public and private decisions. Pardon me. Otherwise, specific laws and planning and development decisions will continue to trump environmental laws every time. Paul talked about that a fair bit. We also believe that approach to law reform would be consistent with not only the custodianship of country ethic, but also ideas to do with the rights of nature and wild law and earth jurisprudence. Now, in pursuing these agendas, the Royal Societies want to continue this activity and with whatever collaborators they can find. So we need everybody's help to make these things effective. You need support, that is, people believe in you and talk about you and so on. Organisation, you always got to have some kind of continuing structure, even if it's only one person, and resources so the one person can do useful things. Thank you very much for your time.
Thank you very much, Dr. Quinn, for your very thought-provoking presentation on how we should change our ways, our legal approaches, practices, and structures to do what we must do for the nature, and how we must integrate the concept of custodianship, custodial approach to land and sea into the contemporary legal frameworks and the polluter pays principle. Thank you very much. Now, let's move on towards our fourth speaker, Dr. Newport Chaudhary. Dr. Newport Chaudhary is an assistant professor of law at the Center for the Study of Law and Governance, Jawaharlal Nehru University, New Delhi, India. She teaches and researches on environmental law and technology regulation. She's a member of the IUCN Commission on Environmental Law. Currently, she's a program director, South Asian Research Colloquium on Environment and Climate Change Law, or SARC. The SARC is a mentorship program aimed at supporting research, publication, and networking among young environmental law academics from the South Asian region. Her presentation is titled Ecosystems Republic, Reimagining Governance for Sustainability. Dr. Chaudhary, I warmly invite you for your presentation.
Thank you very much, Chair. I'll just share the screen. Okay. Thank you very much for inviting me, specifically to the organizers and Paul and Michelle for having me as part of this panel. And I'm very privileged that the presentation actually syncs in very well with the previous speakers, the points made by the previous speakers. So my presentation today is, I would like to speak about this, it's more like a thought experiment. It's called the Ecosystem Republics and Conceptualizing Justice in the Anthropocene. So, yeah, so what I would like to generally speak about is just a little bit about the evidence in the Anthropocene. Of course, the Anthropocene itself as a geological category is in dispute amongst geologists, but amongst social scientists, it has been lapped up quite extensively. So from the evidence of the environmental degradation in the Anthropocene, what is the change that we should, hypothesis that I would like to present to you, and generally conceptualize principles of justice through 3 ideas. And also lastly, to end the presentation by putting forward to you that on the prima facie, this might look at as a really fantastic idea, but in effect, these kind of experiments, as suggested by these principles, are already being practiced in various jurisdictions. And I would like to present to you one such experiment, governance experiment, that we've practiced in India through what is known as the Forest Rights Act. And then I'll conclude with some points. Right, so all of you are aware, I mean, we had the UN Millennium Declaration in 2000, followed by the Millennium Ecosystem Assessment Exercise, which essentially said that the economic system has led to unsustainable environmental degradation, right? And this has been reiterated again in the very recently IPBES report, which essentially says that the current value system and governance institutions have incentivized economic activities over environmental conservation and restoration. And the report itself calls for a transformative changes, and it defines transformative changes as a fundamental system-wide reorganization across technological, economic, and social paradigms, goals, and values. Now, the presentation of mine today responds to this call for transformative change. Right? So essentially, if I could put to you these couple of propositions. First, that the international environmental law regime as we know it, both soft law and treaty-made law, has failed to prevent degradation and damage of ecosystems. It is failed because it's primarily based on the polluter pays principle, which is liability for compensation for harm already committed. Right? There is very little concept of restitution of damaged ecosystems. And the other very important part of the international environmental law is that there is no idea of the disproportionate impact of environmental degradation on vulnerable persons and living habitats. The basic reason for these has been the principle of sovereignty, which essentially is a fundamental principle in international law. Essentially, that means that we recognize states as the only, primarily still, the legitimate actor in the international legal system. And international negotiations have always mired by controversies over sovereignty. And the permanent sovereignty of natural resources, one of the founding principles of international environmental law, has prevented any kind of formation of a hard environmental law regime which would allow intervention when countries actually take action which leads to environmental degradation, right? So also, if you look at the other aspect, which is the International Court of Justice jurisprudence, the idea has been of transboundary harm has been that it's an adversarial litigation system and it only allows for ex post facto redress. And there is still no ex ante prevention of harm. The aerial herbicide case could have led to some action, but then the case was not pursued and we didn't see any jurisprudence emerging from that. So in this context, what is the central hypothesis I propose? The first is that nation states and indeed nationalism is inimical to the idea of environmental sustainability and towards efforts of protecting the integrity of ecosystems. And following from that, I argue that we need to reimagine nation states as a series of ecosystems republics, where the objective is to ensure the integrity and therefore the sustainability of the nation states, of these ecosystems. That would obviously mean that you need to put ecosystems as the fundamental unit of political organization and not states. I just want to recall one of the very important things a conservation biologist, Leopold, he's mentioned that a thing is right when it tends to preserve the integrity, stability, and beauty of the biotic community, and it is wrong when it tends to do otherwise. So the first principle that I would like to suggest is that there's a hierarchy within inter se between the principles. The first principle is that of maintenance of ecosystems integrity, as Nelson correctly mentioned earlier. Without actually taking action to preserve the integrity of an ecosystem, all other actions would be of little value or limited value. And what does ecosystem integrity really mean? It means that you need to support sustainable sustainable life systems. What does that mean? It means securing a system of living that is in consonance with the needs of the natural ecosystems. And it presumes that it is the latter, which is the needs of the ecosystem, that is of highest value. And everything in it, including the interests and associations of all living beings within the ecosystems, is restructured in a fashion to secure the continued sustenance of the ecosystem. The second principle, automatically, there are certain implications of stating it as a first principle. It obviously means that all constituent beings within a certain ecosystem would need to subordinate their interest in a way that allows the ecosystem to function in a sustainable way, right? That would also mean that the extinction of any constituent species in an ecosystem would be morally unacceptable. Also instrumentally unacceptable, because the ecosystem cannot function. It's a relational being in a way, right? And neither is endless reproduction of any species morally defensible, right? Now I draw inspiration from the ideas, very fundamental ideas of Gandhi, which is Swaraj, Ahimsa, and Sarvodaya. The idea of Swaraj essentially means it is he talked about human beings, but also about other beings as well, other living beings as well, is to exercise self-restraint and control their wants and desires by voluntarily practicing a form of precarity in a way, right? Minimizing consumption and maximizing thrift, right? Now, the idea of ahimsa is essentially, I mean, most of you know, is the idea of non-violence. It's fundamentally connected to this practice of self-control and Swaraj, right? That the relationship of non-violence is established between all living beings. And non-violence does not mean complete prohibition of harm. Intentional killing or harming of another, it only means a prohibition on intentional killing, right? Or harming of another being beyond one's needs is what Gandhi finds morally indefensible. Fundamentally, this would recognize the right of all species morally to coexist and the obligation to exercise self-rule. And a concomitant adjunct to that would be a right of every species to exercise restraint or self-rule or Swaraj, right? Vis-a-vis their relationship with other species. Now, the second principle of the ecosystems republics is that it should be governed as republics, which means that you not only recognize all living beings within the constituency as moral beings, but also as political beings, which means that they have a right to be consulted about the governance of that ecosystems. Of course, how would you then, the question is that how would you represent the species interests in such a system? And this has been, I mean, there's enough literature to suggest that this is not an insurmountable problem, right? We have a lot of literature on this, which suggests through stewardship, custodianship, all these are elements in which representation of other living beings, or even non-living beings for that matter, can be done, right? I would also like to suggest that that the principle of subsidiarity is absolutely critical to this idea of ecosystems republic, that all relationships in an ecosystem have to be localized in terms of deliberation and regulation of relationships within that ecosystem. There is also a role to be played by scientific academic experts like biologists, zoologists, anthropologists, who will play the role of an ombudsman, ensuring that there is an external ecological review of the political functioning of such republics. Finally, what is the third principle? The third principle is that every ecosystem is unique in terms of constituents, its conditions, and its topography. And this recognition of this diversity means that governance arrangements across ecosystems cannot be fungible or replicable, right? So that every ecosystem would need a governance arrangement which is particularly suited or sui generis to it, right? And that would mean that there would be no global agreement as to what are the norms and values other than a procedural framework, right? So in that sense, I would differ from Bosselman's writings on ecosystems as a principle of, as recognition of ecosystems within international law. Okay. Finally, this might seem as, when I first presented this idea, it was, it's always seems like what it is. I mean, it's not taken very seriously, but these are governance experiments. These are the inspiration for these. This is already from governance experiments that are already being practiced in various jurisdictions. I would like to present to you one such experiment. The short title of this act, which came into being in 2006, is called the Forest Rights Act. The longer title is called the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006. Now, this act, the background to this act is that since our independence, we have had independence now for more than 70 years, but we've had a very, very colonial forest bureaucracy that has been still practiced in India, which essentially means that the idea of the eminent domain is fundamental to governance of natural resources in India, and forests being one of the biggest natural resources that we look at, right? So the way that we've practiced forest conservation is through enclosure, and that's similar to Wildlife Protection Act, like to take out local people from within vast acres of land and to only close them off for human habitation or use of free rights. Now, the Forest Rights Act actually changed the entire paradigm of such thinking in 2006. First is recognizes there are three aspects of the FRA that I would like to highlight. First, it recognizes that forests are singular ecosystems, and it emphasizes the maintenance of the integrity of that ecosystem. That is the fundamental principle on which the Forest Rights Act is based. Of course, the other very important part is that it inaugurates an innovative property and access regime, both at the level of the individual and the community. So there are individual forest rights recognized as well as community forest rights. And those rights are very unique because these are not rights which can be sold off or transacted. These rights inhere within a person and can be inherited, but it cannot be transacted in the open market. And the rights come with an equivalent obligation of responsibility of protection of that ecosystem, right? So there's a limited subsistence regime that is based on legally protected tenurial rights to property, which means farming, and access to minor forest produce. And that with that, those rights comes the obligation to actually protect the ecosystem as it is. Okay. So finally, to conclude, for long, over the 19th and the 20th century, the state and the market has been the two most formidable and foremost units of political and economic organization. But both these actually presumptive categories, nothing more than that, have failed in actually ensuring environmental sustainability. And the kind of threat we are facing is really existential in nature. I put forward this idea of ecosystem as an alternative form of political and economic organization to address this challenge. Devolution of governance at the level of ecosystems is absolutely imperative. And I think this idea critiques the current international policymaking efforts to address environmental degradation, as all efforts, current efforts, presumes that the state is the basic unit of organization, governance, and action. And this is it's nothing more than a presumption that we really need to challenge and move away from. Thank you very much for your attention.
Thank you very much, Dr. Chaudhary. You shared a very intriguing idea, I must say, reimagining nation states as ecosystem republics to protect the integrity and the sustainability of the ecosystems. Thank you very much. Thank you. Now I think we can move on to questions and answer session. I have several questions in the Q&A option here in the Zoom chat. Let me read out the first question. It is a question directed at Paul. I'll read out the question. Distinctions are often made between biodiversity offsets and pollution offsets, with the former more flawed and problematic than the latter due to irreplaceability of biodiversity. But would you also argue that carbon offsets are inimical to the emerging ethic of responsibility in environmental law? Over to you, Paul.
Thank you. Thanks, Asanka. Thanks, Anita, as well. That's a really good question. I must admit I had a peep at it earlier and sort of started formulating an answer. My short answer is yes. In my my belief, I suppose, my research and the way I've conducted it, I would say yes. Sorry, let me just see if I'm answering the question properly. Sorry. Yes, it would be inimical because, and this is something I didn't get the chance to really, I think, emphasize as strongly as I would have liked in my presentation due to me, I'm not probably practicing the paper properly and running out of time, is the relationship or the contrast rather between the ethic of responsibility and the ethic of rights. Now, the ethic of rights, the ethical framework of rights, it remains the prevailing ethical framework for Western law. And that, of course, extends to environmental law, climate law, both internationally and domestically. And for me, carbon offsetting, despite, and I agree completely with what Anita has said, that it isn't as problematic in many ways as biodiversity offsetting. But the reason why I still think it's inimical to responsibility is because offsetting, even in the climate context, is still something that to me is very heavily embedded, invested in the rights-based ethical framework. And the reason why I say that is because offsetting really is something which allows particular emitters to continue to emit, basically. And so what it's built around is this idea of rather than, I think, sort of delimiting power in the sort of sense of responsibility, it's maintaining some sort of right to development or right to pollute, however you want to see that. And of course, there are important sort of proprietary interests involved in that as well. And that's such a strong manifestation of a rights-based ethical framework in law. So yeah, whilst it's not, I don't think it has the same problems as biodiversity offsetting, I think offsetting as a concept, which then applies to carbon, is also inimical in terms of this idea of responsibility, because it's really, again, and also it's that de-physical property sense. And for anyone who's interested in that idea, Associate Professor Nicole Graham is talking tomorrow, and you know, she is an expert on this area. Again, it's that de-physical sort of sense. It's sort of saying with here are my emission liabilities, but I am going to sort of extract it in a way and then sort of offset it by you know, taking it somewhere else. So you know, again, it's that sort of idea of detachment. Now it's complicated, of course, with carbon because it's a gas, not something that's necessarily on land. But still, yeah, that would be my answer. That yeah, it's still inimical, I think, to that ethic of responsibility.
Thank you very much, Paul. There's another question. I think it goes to Dr. Newport Chaudhary. Could you explain more about ecosystem republics? Who coined these terminologies? Dr. Newport, over to you.
I did, so not much to write back on that. So yeah, well, the paper is in production, so it should be out soon.
All right, thank you very much. I think Gokul, it answers your question. And there's another question. I think it also goes to Dr. Nupur. More of an opinion. Empirically, I'm not sure we can say that international law has failed to protect biodiversity or nature. In order to say that with confidence, we would need to know what the results would have been in the absence of any international law. What are your thoughts on that question, Dr. Nupur?
Yes, yeah. So my opinion on this would be that all assessment reports come to the consensus that we've not done enough. Of course, it's a matter of judgment whether, if it wasn't there at all, should we be facing this crisis earlier than now? But I think more or less, if you look at the fundamental presumptions in international environmental law, the idea of sovereignty, the idea of non-interference in domestic affairs, the idea of permanent sovereignty of natural resources, which still is very much a concern, because, I mean, for example, like a country like India would never sign a forest treaty. For example, one of the declarations that was signed in the recently the UNFCCC discussions on climate change, right? This is of concern, and it depends on how you look at the ambitions of international environmental law. Is it to how would I put it? Is the ambition of international law, international environmental law to actually slow down environmental degradation or to stop environmental degradation? Depending on what is the question you ask, I think the answer would be likewise. Thank you.
Thank you very much. There's another question which goes to Paul. I would like to ask question to Paul Govind, yes, of course. What kinds of efforts that can be performed by the government of a state to deal with the interest of humanity and the nature to be balanced? How is the policy of state in order to utilize its power to embody the protection of nature as protection of human being, because nature is the fundamental element to support the existence of human being?
Thanks, Asanka. And I think that was from Shri, wasn't it, that question? Thanks, Shri, again for an excellent question. Yeah, it's a tricky one. You know, I'm not sure we are ever really, we're not in a position currently, at least in Western legal systems, to really do that. And the reason, I think, isn't necessarily, the reason isn't terribly obvious. There's no direct answer to it. I think where our legal system will struggle to adapt to any kind of reorientation along the lines that I've mentioned is that our legal system is so heavily cloaked in property. I really think that property is absolutely key here. Now, I always, you know, sort of tell people in my belief that property is the cornerstone of the sort of Western legal model. Even before constitutionalism, I think property really is the cornerstone. And property, I don't think we can underestimate its effects on law. And it is such a fundamental manifestation of the rational legal thought that to sort of move against it is almost moving against centuries of what we have built up to be basically how we interpret our relationship, not just with each other, but with the world around us. So property has been this sort of, I used the sort of analogy of a cloak. It's also a bit of a prism by how our legal systems make us view the world. And that is a huge divider. When we look at the privileged position of humanity over nature within the legal context, the great divider is always going to be, well, at least it's going to start with property. So unfortunately, I think until that concept is either modified in some way, and there is some excellent literature from people who are a lot more learned than I am on this, Margaret Davies being one of them, who has spoken about this potential reconceptualization of property. But that's, to me, is the key, Shri, to that question.
Thank you very much, Paul. There's another question, which goes to both Gerald Laring and Nelson Quinn. What is the appetite to incorporate Indigenous law in New Zealand and Australia's state law? What are the difficulties in doing so? Gerald and Nelson?
Wow, that's a big question. It's actually a key aspect of my PhD work is looking at, picking up on Paul's comment, the normative power of property thinking, and the orthodox understanding of what it is to be an owner is something which needs to be overcome, in my view. And while there is an increasing recognition of tikanga Māori, which is it's more than law, but it is effectively within tikanga Māori you have traditional Māori legal concepts. The courts are getting very close to accepting that tikanga Māori is a separate source of law in New Zealand. Be fair to say the sort of the relationship between that and state law is still something to be negotiated and worked out. But I think there is potential in that interaction at re-looking at and reconceiving what it means to be an owner, and what it might be that for some types of property that the orthodox meaning of owner remains as it is now, but not for all property, which is the case now. So that probably has not answered the question because it's far too big, but hopefully touched on what could be the answer.
Dr. Quinn, do you have anything to share on that?
Yes, to repeat the point about property law, that stands in the way of all sorts of progress, not just on this front, social, economic, all sorts. The other thing is the conflicts among laws. If you take the example of Queensland, there are lots of laws that read well, that are consistent with some of those Indigenous perspectives. For example, under our Environmental Protection Act, there is a duty of care on all of us to do no harm to the environment. Now that's simply, I would say, just not implemented, full stop. So it gets back to the point I made before, I think, that too often the planning and activity approvals and that kind of thing, the detail of them tends to override these more general propositions. So the task is to make the detail subordinate to the right kinds of general propositions. That's not easy to do, I grant you that. It's a bit like the question about does international law affect biodiversity protection? Well, of course it does. Speaking as an ex-public servant, when these things are there, they influence what you do. They influence the advice you give. They put people in a situation where they can ask the right kinds of questions and so on. So the impact may be nothing like the authors thought it ought to be, but there are still influences. But to go back to the beginning, the property thing is the big handicap. What I'd call the conflicts among laws that are too commonly resolved in favour of growth at all costs is the big problem.
Thank you so much, Dr. Quinn. I think I have exceeded the time, but I'll take one more question, last question. This question goes to Nagoya Harrison. She spoke of kaitiaki. Are kaitiaki always people?
Kia ora. No, actually, it's actually a contentious issue amongst some iwi or hapu whether kaitiaki were ever people, and that is perhaps part of a consequence of the inclusion of concepts like kaitiakitanga or kaitiaki in the RMA, is that they have become human focused, and in a lot of the especially records like Māori Land Court records and Native Land Court records, often when kaitiaki were mentioned as guardians of a particular place, they would be animals or a sort of non-human entities or the land itself. So there is an argument that the idea of kaitiaki being humans is a much more recent condition of that concept. Perhaps it's something that's come out of the inclusion of Māori terms and Māori concepts and tikanga within Pākehā or New Zealand European Crown law in this country.
Thank you so much, Nagoya. I think we have now come to the end of the third session in the 8th Frontiers in Environmental Law Colloquium. I sincerely believe that this session has equipped you with novel, intriguing, inspiring ideas and innovative legal approaches to protect the environment, not just for us, the present generation, but for the future generations yet to be born, and not only for us, the human beings, but for non-human beings who form a part of the nature as well. So I would like to express my sincerest and heartfelt gratitude to all the panelists for generously sharing their knowledge with us. And also, dear participants, thank you very much to all of you for your very enthusiastic involvement in this session. This has indeed been an amazing endeavor. Thank you very much all. With that, I conclude the session. Thank you once again. I think you will enjoy the rest of the colloquium. Thank you.